Hello, Adam Brady, a claim attorney with Minnesota Lawyers Mutual, here to discuss conflicts of interest with you. A commonly alleged error giving rise to malpractice claims is that the lawyer engaged in a conflict of interest. MLM's Law Practice Management booklet on conflict defines conflict of interest as follows. A conflict of interest is a compromising influence that is likely to negatively affect the advice that a lawyer would otherwise give to a particular client. A conflict of interest situation is a set of circumstances that is likely to affect adversely the lawyer's judgment concerning a client or prospective client, the lawyer's loyalty in respect to a client or prospective client, or the lawyer's safeguarding of interests of a client or prospective client. Conflicts are very troubling because of the fact that loyalty and independence of judgment are essential to the effective representation of a client, and that a conflict might make it impossible to exercise the essentials of loyalty and judgment. ABA Model Rules of Professional Conduct address the issue of conflicts of interest in Rules 1.7 and 1.10. The rules, and especially the comments to the rules, provide detailed direction that is invaluable. If followed, they will assist in avoiding the majority of the malpractice and ethical traps presented by conflict situations. Although the rules do not in all cases prohibit representing clients with conflicting interests, doing so is extremely dangerous from a malpractice standpoint. This is especially true if one of the represented parties does not believe that expectations were met. And in a malpractice context, a conflict of interest claim just plain makes things look bad. Even with what appeared to be an informed consent documented in writing, if the deal goes bad, chances are a claim will be asserted against the lawyer by those parties who believe they did not get all they deserved. Such claims can be defended successfully, but they are still not without a cost to the defendant and/or lawyer. If a professional liability policy provides coverage for the claim, there may be substantial deductible at risk for the lawyer. In addition, there will be significant amounts of unbillable time spent with claims personnel and defense counsel. The most effective way to avoid conflict of interest claims and ethical problems based on conflicts of interest is to decline any representation where a conflict exists. Although this is an effective technique, it is not always a practical alternative. Instituting some relatively simple procedures will assist in managing these risks. First and most importantly, all actual and potential conflicts should be identified to the extent possible before representation is commenced. This will entail collecting certain information about all prospective clients and cases. Ideally, this information should be collected by telephone prior to the initial client consultation and should include the prospective client's name, home, business address, and all the prospective clients' telephone numbers. It is also important to secure the prospective client's employment and business affiliations and other involved and interested parties to the matter, whether friendly or adverse. If the information is not secured prior to the initial meeting with the client, it should be gathered at the time of the initial meeting by means of a client intake form. Once gathered, the information must be entered into the system. One staff person should have the responsibility of maintaining the conflict system, and the system should be centralized. Conflicts checks must also cover current and former clients with new matters. In order for a conflict system to be effective, all attorneys and support staff must be thoroughly trained in the system, must buy into the use of the system, and must actually use the system. If a conflict is identified, and if taking on the representation is being considered, an analysis must be done in order to determine whether the conflict is waivable. This analysis must be done by a close examination of the applicable ethical rules. If it is determined that the conflict is waivable, then before proceeding with the representation, the client must give an informed consent. This consent is required to be given in writing under the ethical rules in most jurisdictions. If the conflict is determined to be non-waivable, or for that matter, if the case is declined for any other reason, including a gut-level feeling of being uncomfortable with either the case or the client, there are important steps that must be taken. Do not obtain any confidential information in the process of screening the client and the case. If confidential information is received, obligations to the would-be client could accrue, even if the case is declined. If a case is declined, it is crucial to document very clearly the declination. A non-retainer letter must be sent immediately in order to document that the case is being declined and that there has been no attorney-client relationship formed, and also to advise the would-be clients that certain time limits could apply to bar the case and that they should seek other counsel immediately if they intend to pursue the matter. Finally, the letter should confirm that you have received no confidential information. The letter should contain no opinion as to the merits of the case. It is recommended that the letter be sent certified, return receipt requested. Following the above suggestions will provide guidance to would-be clients if they choose to pursue the matter and a defense if it is alleged that an attorney-client relationship was established. Following these suggestions will also reduce the likelihood that a successful malpractice claim or an ethical complaint resulting in discipline will be proffered.